Hi, welcome back to Finally Revealed. In this episode, I want to go over 20, and these are not all of them, but I want to go over 20 bankruptcy terms, some other videos talking about the individual chapters and some other areas, but I thought it would be helpful to put definitions in one section, and so I will link this to those other videos so that it's easy to find if you need to come back again. I realized by going through this list I'm going to have to do another video because there are some other common terms that are not on this list, but I don't want to make the video too long. So without further ado, here are 20 bankruptcy terms. Debtor. The debtor is the person or entity who the case is about. So if it is your personal bankruptcy, you are the debtor. If it is your employer, XYZ company files a Chapter 11, XYZ company is the debtor. Creditor. There are two main kinds of creditors: an unsecured creditor and a secured creditor. A secured creditor is a person or entity who is owed money from the debtor and has collateral to back up that debt. An unsecured creditor is a creditor who is owed some money without collateral. An insider. An insider is a person who has control over or a means of control of a company, either an LLC, a partnership, a corporation, and that entity is the debtor in bankruptcy. Trustee. A trustee is an attorney who is appointed by the court to oversee a Chapter 7 case, can be used in an 11 case, and then there is usually a standing trustee who is one person who is over all Chapter 13 cases. The trustee reviews the schedules and statement of affairs that are filed. They conduct the 341 meeting of creditors. They represent generally in a Chapter 7 the interests of unsecured creditors. They look for fraud and refer that on. And that gets us to the next term, which is the U.S. trustee. The office of the U.S. trustee, there is a U.S. trustee for each federal district, and they oversee all of the bankruptcy cases, prosecute bankruptcy fraud. They collect fees in a Chapter 11 case and oversee the administration of that case. And so they're like a level up from the Chapter 7 trustee and over all of the cases. Next we have the automatic stay, or sometimes just called the stay. The automatic stay or the stay is what is enacted, what is triggered upon the filing of a bankruptcy petition. A voluntary case where the debtor seeks bankruptcy protection. Once the petition is filed, an order is generated by the bankruptcy court staying any enforcement action against that debtor. Collection actions have to stop, and there are penalties for any of those actions that continue after the automatic stay is issued, and that will lead me to a term on the next video. Relief from stay or stay relief, it means a creditor who comes into court according to various rules in the case and in the bankruptcy code can ask the court to have the automatic stay not apply to their situation and let them continue with the action that they were taking before the bankruptcy was filed. Next is reorganization. You'll hear us talk about this in Chapter 11. Reorganization is the remedy that the debtor receives in a Chapter 11 if it is a reorganization bankruptcy, and that is to reorganize its debts and its obligations and contracts and such as that. And the goal in a reorganization case is for the company to come out of the bankruptcy. So they're not getting out of the debts and giving up the ownership and the rights in the company, but they're reorganizing. Next is the discharge. It goes kind of hand in hand with a reorganization, because remember, a company or an entity, a corporation, an LLC, a partnership does not receive a discharge. The only debtor in a bankruptcy case that receives a discharge is an individual, a person. The discharge is an order from the court at the conclusion of a case involving an individual debtor that discharges the debts that are allowed to be discharged in that particular case. In a Chapter 7 case, that's typically all of the obligations that the person owes when they file, except for certain taxes, some student loans, and I have another video on what is not discharged. But the discharge is the order that those obligations no longer have to be paid. Next, there's an objection to discharge. This is a type of action that can be brought in the various bankruptcy cases where a party asks the court to deny a discharge. Most commonly, this would be based upon some type of fraud. But an objection to discharge is where they're asking for the discharge to be denied across the board as to all the debts. There's another kind of action, and that's the next phrase, objection to dischargeability. And that is where a particular creditor or party comes in and asks for the court to not let that particular debt be discharged. Next, we have schedules. And you hear this throughout all the videos. The schedules are what are some of the documents that are filed in the beginning of the case. Actually, everything is electronic now, but you will, if you are a debtor, you will be reviewing these most likely still on paper with your attorney. The schedules, they have letters, and they are like A, B, C, D, and so on. It is a list of all of the real estate, all the real property, all the personal property, all of the secured debts, all the unsecured debts. It goes on to show cash flow and budget and exemptions and what you want to do with particular types of property and who else owes on these obligations besides you, and those are the schedules. The next thing is called a SOFA, or Statement of Financial Affairs. This is another report that is filed at the beginning of the bankruptcy case, and it is a series of questions that the debtors ask. Every person or every entity who files bankruptcy, the schedules, the Statement of Financial Affairs, and the petition are uniform throughout the United States because, remember, bankruptcy is a federal law, so it applies to everyone. Some individual procedural differences among the different courts, but these forms are the same. The Statement of Financial Affairs asks for things such as last tax returns. For an individual, it will be how much your income was over the last few years. If there are any lawsuits, what are the names of those lawsuits? Where are they filed? Who did you pay money to in the last 90 days or 120 days or 1 year before the filing? If it's a company, who are the owners of the company? Did you make any conveyances to relatives? Did you make any payments to your attorney for the filing? How much was that? Things like that. So that's Statement of Financial Affairs. And I should have put these in a different order. And then the next term is petition. And the petition is the formal request for relief under the particular code section that you're seeking as the debtor. And the petition, the schedules, and the Statement of Financial Affairs are usually filed all together at the beginning with the disclosure for the attorney, with your statement that you took your financial class, and paying the filing fee. Sometimes in an emergency case, all three of those petition, Statement of Financial Affairs, and schedules can't be filed right away, and so the petition is filed with one or more of those, and then an order is immediately generated by the court saying you have a deadline to file the remaining piece of that puzzle, and if not, the case will be dismissed. So those go together. Exemption is the next term. Exemptions. There are federal exemptions and there are state exemptions, and whether your court follows the state or federal exemptions is different. But each state has a set of rules on what property or money or earnings or rights its citizens have against creditors. That there are certain things that no one can take away from you unless you give them permission to in some type of a contract. But for example, Kansas, Texas, and Florida have 100% exemption for your residence, your homestead. Other states, you have a certain amount of equity in certain types of property. Some types of jewelry are limited. Vehicles might be limited to number or amount. Life insurance, cash surrender values, things like that. So exemptions are things that cannot be taken away from you in a bankruptcy to satisfy creditors. Means test. Means test is something that was new. Congress added it to the requirements for Chapter 7 in the last revision of the Bankruptcy Code. And what this provides for is that if you want to file a Chapter 7, which is a total liquidation of your debt, you have to show that you satisfy this means test, that your income and your eligible assets fit within certain parameters. If you don't fit within those parameters, then they will not let you file a Chapter 7, or you could try to file and might be disqualified, but you are not eligible to file a Chapter 7, so you need to file a Chapter 13. And we have another video, and I'll link it below, on the difference of those chapters. Two more. The next term is a 341 meeting. 341 stands for a code in a section in the Bankruptcy Code. And the 341 meeting is held in every kind of bankruptcy that there is. It's held near the beginning of the case. In a Chapter 7 case, it establishes the beginning date for deadlines to run for creditors and other parties. And it is a time where you show up to a meeting room, sometimes in the courthouse, sometimes in another office building, and the trustee of your case is there, your attorney is there, and your attorney asks you questions to have you verify that your schedule and statement of affairs was correct when you filed it, that you reviewed it before it was filed. They ask you questions about whether you need to update or change any of the information or add any information. The trustee then will ask questions about the things that were included on your schedule, statement, and statement of financial affairs, and creditors can show up and ask questions at that time as well. It is recorded on the record. People can get copies of the transcript of that meeting for use later, and some trustees will let anyone ask questions as long as it takes, and others will limit it as to time. And then the final term for this video is adversary action. An adversary is a separate lawsuit inside of a bankruptcy case. So if there is a creditor who wants to object to dischargeability or a discharge of a particular debt, they will bring a case, a lawsuit against the debtor in the bankruptcy court. And it is assigned a different case caption name and a different case number. And usually they have to be resolved before a debtor can receive a discharge, or at least as to that particular creditor. There are a variety of types of claims that can be brought as an adversary action, but that's what that means. And adversary is usually first discussed by the debtor when they meet with their bankruptcy attorney, in particular in a Chapter 7 case, when the attorney is going over their fee agreement, because many times they will not include an automatic representation in an adversary case. But you'll have to discuss that if and when that situation arises. So this might be a little longer than I anticipated, but I hope that this is helpful to you. We have some bankruptcy videos. Check them out in the playlist, and we have some coming out contemporaneously with this video. So I wanted to have these terms available for you for your reference and to just help you. If this was helpful to you, give us a thumbs up. Leave a comment below if you have any questions. Subscribe to see the other videos, and come back and see me next time. Thanks for watching.